So good afternoon, and thank you for joining us for this policy committee meeting. It is being recorded, and the documents which will be discussed here today are available on the event calendar on our website, which is wmc.wa.gov. I'm Amelia Boyd, and I am the program manager for the Medical Commission and the organizer for this meeting. Panelists, please make sure your line is muted if you are not speaking. Christine Blake is the chair for the policy committee. Once a presentation is finished, Ms. Blake will open the floor for committee and public discussion. Attendees, if you would like to ask a question or speak, please use the raise hand function. And with that, I will hand it over to Ms. Blake, and I will work on getting the agenda pulled up.
Thank you, Amelia. While we wait for Amelia to bring up the agenda, I want to thank everybody for spending some time with us here this afternoon. Much appreciated. Our initial process that we're looking at, proposed policy. Actually, it's the procedure which is processing complaints against medical students, residents, and fellows. And I think there was a comment that we might want to take a look at from Rashi Gupta from UW. So Dr. Kohlmeyer, who is not with us any longer, was going to reach out. So he reached out to us instead, knowing that she wasn't here. And in his comment, as in the description of the process, it will be important always before investigating a student or resident to notify the supervising program director. And in the case of medical students, their senior dean of students, and for residents, their designated institutional official, DIO, in the GME office. Are there any questions or comments about that? Or concerns about adding that in? Do we want to add that into our process?
I would have to take a look at it because we're trying to convert this from a procedure to an actual just policy. So a lot of the procedural aspects have been removed.
Okay. I
think it makes sense. Oh, sorry.
No, I'm sorry, Dr. Trescott. I was just going to ask if people had a chance that are online here to take a look at this, to read it prior to.
I did take a look at it, and I like the idea behind it. I guess where I got a little hung up on is presenting the complaint. So if it's a medical student and it goes to the dean, it'll be on this person. It could be on this person's letter that they have to use to get into any residency in the dean's letter. And so I'm just worried a little bit about expanding who it influences or how it influences them. That was my only concern. I like the idea of maybe even have it go through their supervisor more than through us as to what will be done, and expect a reply from whoever their supervisor is as a response. That's what I was thinking about.
So as I read Rashi's comments, as well as the referring student complaints, as I'm reading that, it does appear to align with that comment already. So the intent, or the policy intent, is to for students and residents to refer that back to their supervisor or the program director or dean, because as it states on the screen, they're generally better equipped to do remediation for med students and fellows, or med students and residents. I'm sorry.
Mm-hmm.
I wonder if in forwarding it to them, if we could have some information with the letter about being sensitive to the fact that that not all complaints are valid, and we would caution the receiver of this to treat it in a way that it does not have a deleterious effect on their future employment. I don't know exactly how I'd say it, but maybe something in the letter that guides the reader of this complaint to get a feel for what the complaints are. I take it these are only going to be the complaints that have already gone through CMT. If they're rejected by CMT, they won't go through.
This is just speaking to the policy of how generally the commission will approach a complaint on these particular categories of trainee or practitioner. So it's not going to detail out. It has to go through CMT and then it has to be referred. It's simply if we get something on the policy, unless it comes into a specific category of complaint, it's all going to just simply be referred back to these people.
And this is Heather. That's reiterated again later in the document as well, that point that Mike is making.
Yeah. And in particular, with respect to medical students, you don't license them. So it would be more of an unlicensed issue anyway if you got a complaint on them.
Right.
Even though there is a licensing exemption in 1871-030.
Any other comments?
I will point out that we spent a lot of time internally on this particular section about fellows. There was a great amount of debate just simply about how to approach them. Should they get the same treatment as a med student or a resident? Dr. Kohlmeyer really felt pretty strongly that fellows should be treated a bit differently since they sort of bridge this gap between residency and full independent practice. So that is reflected in this draft, to where I would just say that fellows get a little bit less of a pass.
I mean, I'm only the one talking, and I welcome anyone else to speak, but I find it pretty acceptable with those caveats.
Okay.
Do we have anyone from the public that has any comments or hand raised? Amelia?
There aren't any hands raised yet.
Okay. Does anyone else have any concerns? Mr. Rogers, do you have any questions or concerns?
I do not at this point, no.
And then I just have a comment. Since we are converting this one, we're proposing to convert this one to a policy, it would also go through the same process that the secretary would need to review. So when it's brought to the business meeting, we're asking them to approve it for secretary review.
Okay, if there are no other comments or questions, then we'll move to the next policy and present this at the business meeting.
Are you going to take a vote
Go ahead.
to
Oh,
approve
yes,
it?
sorry. Yes, apologies. Motion to approve.
Second.
So moved.
Well, okay, thank you. And second. Okay, I'm not the mover. Thank you so much. Okay, we'll move to the next one. Commissioner and pro tem recusal policy to address conflicts of interest. Does anyone have any? I did not see any concerns myself when I looked this over. It looked pretty straightforward to me. I don't know what everyone else thinks.
Nor did I.
Yeah, I thought it looked good.
May I have a motion to approve as is?
I move we
So-
approve it. Oh,
Second.
you can have the next ones.
So all in favor?
Aye.
Aye.
Thank you. Our next document is a guidance document, medical directors' roles, duties, and responsibilities.
So this one is just up for its 4-year review. No one has suggested any changes to it. So if you just want to reaffirm it as written, that is fine, or you have the option to make changes to it.
Any comments, concerns?
Not a concern, but I'll add some background to this. So we historically had not had this as a guidance document, and we ran into a regulatory action issue that really stemmed from a medical director overextending themselves and not performing the roles that were generally expected. However, medical directors can be basically anybody that's licensed, and it's pretty agnostic when it comes to the license type that they have. And so the development of this was really to provide some concrete requirements is probably a strong word, but some just line out what the commission thinks are the responsibilities of a medical director, whether they be in a hospital or a clinic setting. So during the time of development, there was also the concept kicked around that maybe we need to consider doing rules. There were also some conversations with legislators who seem to have some sort of an interest in making it a license type. So just have that awareness as you're looking at this, that was the origin. And if you feel it needs to be stronger or changed in its scope or type, make it a policy or a rule or something else, please let me know.
So I apologize, and I'm sorry I'm not raising my hand. But I haven't reviewed this recently enough. And I'll take a better look at it after the meeting, but I have some concern about, we've had disciplinary issues with medical directors where how they act as a medical director is the problem, where they're disruptive, that they're having a negative impact on the staff. Also, then there should be some understanding that they are responsible for the clinical policies and procedures in that facility, and that they know them and they follow them and that they could be held responsible for them. And you might just have to tell me if we got into any of that.
If we could scroll down a little bit, it does list
Mm.
out those
Yeah.
duties, specifically the clinical standards and that sort of thing.
Yeah.
And that was frankly what was at issue in the regulatory action that I'm referring to. But I will point out, this is a guidance document, so
Right.
it's for the licensees. If you were to try and use this as the basis of a disciplinary action, regulatory action, I think Heather would probably give you some pretty strong advice to the contrary.
So are you saying that means we would not be able to have as the discipline that they could not hold the role of medical director in the future?
I would defer to one of the lawyers on that. The way I've always interpreted this is you have a disruptive doc policy, right? And when we have taken action on disruptive docs, we have cited that policy specifically. And so that's, while it's not the basis of the discipline, it provides the policy blueprint for how you will approach a complaint involving that. This is a guidance document, so therefore it is not enforceable. It doesn't have the level of authority of a policy or a rule or interpretive statement, or certainly a statute. So it's really just giving an FYI to the licensee, while not lining out the specifics that you could take with respect to citing it as the reason that you're taking a disciplinary action. You would still need to have it under the Uniform Disciplinary Act of the 26 or 7 or 8 violations or potential violations.
I'll just second that. Yeah, that's correct. So you can't charge someone with violating the guidance document. You would charge them with a violation of under the Uniform Disciplinary Act of unprofessional conduct. That's not to say as part of discipline in the appropriate case, you couldn't sanction someone and restrict their practice to say you shouldn't serve as a medical director, that could be a sanction in an appropriate case. So you're not restricted in that regard, if that's what you were getting at.
Yes, thank you. That's great.
Dr. Trescott, are you comfortable with moving this to the business meeting, or you had mentioned you wanted to take a look at it a little more after this meeting?
I think I'm fine with moving it to the business meeting, and after I review it, I can bring something up to you by email if I've got some concerns, okay?
All right, thanks. Mr. Rogers, do you have any comments?
I do not.
And nothing from the public, Amelia?
Doesn't appear to be, no.
Okay, so that I need a motion to approve. this
Scott, I think
document.
you should do this one.
So moved.
I'll second.
All in favor?
Aye.
Thank you.
Aye.
Thank you. Our next document is the proposed interpretive statement for qualified physician under optometry law. And I saw that it was reviewed by Dr. Domino, who unfortunately looks like she couldn't make this meeting.
I think we skipped
Oh, did we
something.
skip one?
Yeah, I thought recusal
Yeah.
was next.
We did recusal.
Oh, really?
Yeah.
Yeah, you did this one already.
Oh, okay, my
They,
bad.
they
Sorry.
had no comments.
Easy enough.
Yeah.
Moving on.
So Dr. Domino, unfortunately couldn't be present, but she did take a look at this. And all the redlining and in the document, hopefully people have had a chance to take a look at it prior to this meeting. And I think that we also had some comments on this one, if I recall, from the agenda from the outside.
Yep.
Yeah.
And this was read at the interested parties meeting. This comment.
Okay.
So, because we got it like the day before that meeting, but it was in this packet, so. And I think Kyle has his hand raised.
Oh, yeah, he does. Kyle?
Thanks, Ms. Blake. I just wanted to add, the redlining is largely mine, and it was some edits that I did after the interested parties meeting in the interest of kind of further outlining the commission's lane with regard to this interpretive statement. When the legislature passes laws like this, the underlying change to the optometrist scope of practice, but also requires interaction between the Board of Optometry and hopefully the Medical Commission, and potentially also the Board of Osteopathic Medicine. We end up in a situation where there's always room for disagreement. This interpretive statement in one form was before you last November, and ultimately it was tabled because there was an indication that we wanted to wait. The commission wanted to wait until the Board of Optometry had done some of its rulemaking. We did informally consult with them. Dr. Murphy and I did last May. I've talked to the Board of Optometry staff a handful of other times to kind of keep tabs on where they were going. They chose not to accept any advice or input from the Medical Commission. I think you saw in your meeting materials at the last business meeting, there are a number of complications with regard to some of these procedures that can be quite serious. And in order for somebody to be able to treat these kind of on short notice and in a kind of efficient but also clinically competent manner, the commission and the folks that we've talked to feel strongly that the consulting physician or the partnering physician for these should be somebody who is either an ophthalmologist or a board eligible physician, ophthalmology board eligible. And so that's been written in and changed. And then you'll also see an adjustment to some of the language. Amelia, if you don't mind scrolling down, to make clear that, you know, the commission is not seeking to regulate optometrists or the Board of Optometry or any of that. What we're doing is defining what we consider a qualified physician to be able to partner with optometrists in these situations. Some of this language, Heather, I apologize, you haven't seen this before, but some of this was after a discussion I had with you with regard to kind of that staying in your lane approach that we're talking about. So again, I hope that it fits the bill. And certainly, Heather, I'd be interested in your input here.
Then we have a hand raised. Susie Tracy.
Thank you. I appreciate having the opportunity to make any comments today. I really have very little to add to the letter that the Washington Academy of Eye Physicians and Surgeons presented to you and that was read. I'd also like to concur with Kyle's comments about staying in the lane. While the ophthalmologist might really have enjoyed your having a position on the legislation as it passed, we do recognize lanes. But I think that in terms of valuing vision and proper caring for eyes and any complications that might arise from surgery, that ophthalmologists are the only ones that can be considered qualified to work with optometrists if there is a complication. So we appreciate the work that you've done so far, agree with it, and hope you'll move it forward. Thank you.
Thank you.
And Heather, if you wanted to go ahead.
I've got the sun coming in my office right now. I look like a giraffe or a zebra. I support the additional language, Kyle. I think that's good. In red on the second page, I think that's appropriate.
Thank you, Heather. And then Hillary from the audience.
Oh, hi. Thank you for the opportunity to comment. Hillary Norris with the Washington State Medical Association for the record. I just wanted to go off of what Susie just said and just state that the WSMA represents physicians in all specialties, and we concur with WAPES that only ophthalmologists have the training and expertise to respond to adverse events in and around the eyes. And so we support the interpretive statement, and we appreciate WMC's action on this. So thank you.
Go ahead, Kyle. Oh, you're muted.
Sorry, I just missed. I missed a typo in the last sentence. In the second to last paragraph, it should read, "This interpretation is intended to assist physicians who are contemplating entering into an agreement." That's my own lack of nuance and skill with redlining in a formatted document like this. I apologize, but I think we should probably fix that sentence going forward.
I'll fix it.
I think the Queen's English is who be contemplating. So yeah.
That is not correct. Amelia,
Yeah.
if you can fix it, thank you. I appreciate it.
So we are talking about, oh, do I have the right one? Yes, I have the right one. Oh, this doesn't have the red lines. Never mind. I will fix it in the red line.
Yeah, I think it's the one that is just above, but that's okay. Are there any other comments or questions, concerns? If none, then may I have a motion to approve with the changes as noted?
Thank you for the public's comments, and I move to approve as modified.
I'll second.
All in favor?
Aye.
Aye.
Thank you. I think that is the last document that we need to review at this meeting.
Yes.
I appreciate all of your attendance and the time you took out of your day today to be here. And this meeting is adjourned.
Thank you, everyone.